Welcome everyone to today's presentation as we kick off our commercial network webinar series. I'm Jeremy Yohe, ALTA's Vice President of Communications, and today we've got a great presentation lined up to discuss changes to the ALTA NSPS Land Title Surveys, which actually went into effect earlier this year. Before starting, I do need to touch on a few housekeeping items. All participant lines are muted for today's discussion. If at any time you do have a question, submit them in the questions box. We'll hold some time at the end for Q&A. Today's webinar is being recorded and will be available on ALTA's website at alta.org/webinars. Again, that's alta.org/webinars. You'll also get a follow-up email with a link to the recording. And you can download a copy of today's presentation from the handout section. We do need to thank Dell Technologies for sponsoring today's commercial network webinar. And before introducing today's speakers, I have a short message from Dell.
We started with computers. We didn't stop at computers. We didn't stop at storage. We didn't stop at cloud. We didn't stop at wholly integrated intergalactic solutions. We kept going, working with our customers to enable the kind of technology that can guide an astronaut back to safety, or help make a hospital come to you instead of you going to it. And we didn't stop there. We're even working to make packaging that comes from waste instead of producing it. Because we saw a world that was full of challenges and ready for solutions. So when it comes to your business, you know we'll stop at nothing.
Okay, all right. Thank you, Dell, for that message. And now let me introduce today's speakers. Join us. We have the luxury to hear from two industry experts who both serve on the ALTA NSPS Land Survey Work Group. First, we have Gary Kent. Gary chairs the survey work group and is owner of Meridian Land Consulting LLC. And also joining us is Todd D'Amico. Todd is vice chair of the work group and is director of operations for First American Due Diligence Services Company. Gary and Todd, thank you for joining us today, and I'll turn it over to the two of you.
Right, thank you, Jeremy. The work group came up with a draft for the new standards back in September, I believe, and both ALTA and NSPS adopted that draft in October, effective on February 23rd. There are a lot of changes in there, and in our hour, we're not going to be able to go through everything, but there are some significant ones that we want to make sure we touch on and explain. In the handouts portion of the webinar platform here, there is a copy of this PowerPoint. There's also a copy of a handout that has 4 different things in it. First, it has a red-lined version of the 2016 standards showing red underlines and red crossouts, red strikeouts as to what was added or deleted from the 2016 standards to create the 2021 standards. There's also a clean copy of the 2021 standards there. There is also a copy of HUD's multifamily interim instructions, on the 2021 ALTA NSPS standards, and I was kind of floored. They got those out actually on March 25th, only a month and 2 days after the effective date of the new standards. So those interim standards or those interim instructions are out there, and those are in that handout. And then lastly, there are a set of FAQs which really were produced mostly for surveyors, but there is a lot of information in there that might help explain questions that that you might have. I believe all of those, I know all of those are available on the NSPS website, nsps.us.com. And I think those are, all those same documents are probably also available on the ALTA website, alta.org. What we're going to do today in the hour that we have is cover the primary changes, the things that really would either might draw your eye or that are significant and that everybody needs to be aware of, either when they're ordering a survey or when they're reviewing a survey, because there will be some things different in both of those cases. So we're going to look at some changes. The standards include 8 sections, sections 1 through 8, and then Table A, which has 19 optional items. Again, we're just going to hit on the main changes today. So we'll go ahead and get started. These used to be the ALTA ACSM standards that changed in 2016 when ACSM, American Congress on Surveying and Mapping, and the National Society of Professional Surveyors kind of merged, and NSPS was the successor organization. Just a quick background, this is the 10th version of these standards. ALTA and NSPS have kind of an agreement that we're not going to turn around and revise these standards every year or two unless something drastic happened. We're on a 5-year cycle, so the next time around, unless something really needs attention, will be not before 2026. Todd, do you want to?
Yeah, thanks, Gary. So we'll go over a few things in each section today. In section 1 is the purpose of an ALTA survey. Section 2 is the request. We'll touch on contract documents and those things. Section 3 will touch on standards of care, and section 4 is records research. You'll see in the records research, if you have the red line copy downloaded and follow along with us, we've kind of worked that area, it looks like quite significantly, but really just reworded that section. Section 5 is field work, which is what the surveyor and the field crews do out in the field. Section 6 is the plat or map, and section 7 is the surveyor certification. And section 8 is deliverables. Then we'll get into the changes we made in Table A, which there are a few significant changes and some wordsmith changes along the way, and we'll go through that section as well. Section 2, request for survey. We have some very specific language in the ALTA standards that talk about how this should be done. It should be done in writing. It should be a contract between the parties, the party paying for the survey. But what we've also done this go around is there was a court case with the word shall versus must, and we've changed that in the standards majority of the way through where it was appropriate. And you'll notice that change flows through the document itself. And here you can look this case up if you'd like to later and read through that, but you can see why we made that change versus shall versus must. And Gary, if you want to expand on that a little, feel free to.
Yeah, only that, sometimes things change and people think there's some hidden agenda behind things. This was just a case where, prior to this Lamagno case, everybody understood that the words must and shall were basically synonyms. They were both imperatives. They were commands that you had to do something. And in this case, the U.S. Supreme Court, in their decision, held that the word shall was, in fact, not a command. It was what we would call a false imperative. And if you want someone to have to do something, you need to use the word must. So we simply went through the standards, and in every occasion of the word shall, where it was intended to be an imperative, we substituted the word must. Nothing, no hidden agenda. It's just that the word shall is no longer what we thought it was. And as I say to people, somebody needs to look at the 10 Commandments, because I think those are now optional apparently until those get changed.
Yeah, that's another presentation, right? So, also in this section, the client shall secure permission for necessary access. And in the standards, we've expanded power poles 10 feet past the property line. But also, if we get into some of the Table A items, the Table A item with the easements and improvements inside of easements or offsite easements, then that's an important point to actually call out. So not only does the property need access verified and secured, but also possibly offsite easements. And in today's world, every transaction is confidential. So this is a bullet point we've added today to kind of point that out and just re-emphasize that.
Yeah, and I might add that in a number of states, surveyors have a legal right of entry when they're conducting surveys. How far that can be stretched probably remains to be seen in a given state, but that is certainly not the case in all states. I'm from Indiana, we have right of entry. My impression is maybe half of the states, that's probably a little optimistic, where surveyors have right of entry.
Yeah. Section 2, the request for survey, we added some language here, changed some language into mobile home parks, but we added in also surveys for non-fee interest, including mineral interest. And in some cases, an ALTA survey can be done on something other than a fee interest, and we had language in there for that, for easements and things like that, but we added also mineral interest in there. You can do an ALTA survey on a non-fee parcel, and we wanted to make sure we expanded that. Again, this section talks about discussing the scope with the affected parties. It also asks again about written authorization, access again, and then shall versus must. And really not a big change in this initial section, just re-emphasizing and then changing a few of the wordings. Section 3, survey standards. Let's dive into that section next. Resolution was stricken from the heading, and surveyed property was added, or property to be surveyed. Just again, some language changes here, not big substantial changes in the way of what you should be looking for in a survey, just more language and cleanup from the committee on this section.
On section 3E, this is the measurement standard, and I'm not going to dwell on this, but it's always been critically important that the consumers of these surveys have confidence that the surveyor is conducting their measurements appropriately, precisely, or with an appropriate precision based on what the property is going to be used as. And this falls in two different ways. One of them is with respect to the boundary itself, and the other is with respect to locating the features on the property. Section 3E addresses the measurement standards as related to the boundary itself. It's technical stuff. ALTA has always told NSPS we need technical, we need measurement standards, but that's your gig. We just want to see them. That's up to you. And we have had measurement standards since 1962. They've changed a couple of times, but they've been consistent for about almost the last 30 years now. And the measurement standard is called relative positional precision. We made some modifications to that are technical this time around. They're not going to they will not be reflected on the survey. No user of these surveys is ever going to see a difference there. It simply clarifies and simplifies the application of the measurement standard for surveyors. I just wanted to mention that because if you look at the red line version, you're going to see some changes there, and that's all that is.
Section 4, records research. Again, we modified this section. It was rewritten and reordered for clarity, but again, like Gary says, you'll see that we redlined this section quite extensively, but in reality, we moved things around, reworded some areas. But that section also is what's the responsibility of the surveyor, what's the responsibility of the title office providing information, but there's no new major substantial changes to that section. Again, you'll see it redlined up quite a bit, but it's really more organized. So, and in that section, the surveyor must be provided with the following items. You'll see in section 4, a current record description of the property, most recent evidence of title, copies of certain public recorded documents like adjoiners, easements benefiting the property, easements, servitudes, or covenants burdening the property, and that's usually generated in a Schedule B2 listing, right, in the commitment that's provided to the surveyor. And also copies of unrecorded documents which the survey is to make reference if they're available. Here in Oklahoma, we have these things as surveyors we love called unrecorded plats. They're a lot of fun. We had to go to the courthouse to find them. You know, sometimes the title companies know about them and they'll send them to us. So in an instance like that, that would be an example of an unrecorded document. But that information should be provided to the surveyor. Doesn't negate the surveyor from doing their responsibility for their state standards for what their research is. But these are items that we put in the standards that say, you know, the surveyor needs copies of these in order to complete the ALTA survey and do their work and review, so that ultimately we can get to a survey that you can benefit from that's intended for you to help provide title insurance. Section 5 is field work. And we added a few items in here. Field work must be performed on the ground. That's always been in section 5, unless negotiated, related to table A item 15, which is the use of aerial photography, and then that must be disclosed, negotiated, and agreed upon in the beginning of the project. Also, you added non-boundary features located to the appropriate degree of precision based on the following things: the planned use of the property or the existing use. And a prudent surveyor should be asking their client those things. What's going to happen with the transaction? What type of transaction is it? What are we doing after the survey? What's the survey being used for? Those things, especially if certain table A items are being asked for. So we added also just non-boundary features. Boundary precision, again, was addressed in section 3E, which Gary mentioned a moment ago, which as surveyors we could talk for 3 or 4 hours about, but we won't do that today. So section 5 of the field work, we highlighted in this slide the certain major items that should be captured during that field work process. Obviously, monumentation. We need monumentation in order to prepare boundary resolution and determine that boundary of the property. Rights of way and access. It's important for the surveyor to identify those items, especially access on properties. Identify, is access right adjacent to the property? Is it through an easement? Is it through a private drive? What are those things? Lines of possession and improvements along the boundaries. That's obviously an important item. Buildings and structures, that's something that should be picked up in the field. Those items are important to note depending on what's required on the survey. If there's zoning setbacks and things, buildings can turn into encroachments or items that need to be disclosed. Easements and servitudes, we talked about the title office providing that information, but potential easements, evidence of easements, those things need to be picked up in the field. Paths, trails, things that have been used for years and years, those things that are observed in the nature of doing the field work need to be picked up. Cemeteries and water features, those are some other items that need to be picked up in the when conducting the field work. Section 5 talks about easements and servitudes, and in this section we added some information. We went through section 5E. We talked about adding appear to effect, or replace appear to effect with are or on across. Also, this is a section we identified utility poles, where we felt utility poles within 10 feet of the subject property may be an issue in the survey if they cross the property. So we expanded the distance on that, and our intent with this section was for the utility pole and the line, not any other utilities past the 5 feet. And Gary, you feel free to jump in here also, but the wordsmithing of that section was really to identify that and help identify if that's an encroachment or establishes an encroachment as that utility line may cross the property.
Yeah, I might comment two things. That replacement of the phrase appears to affect. One of the things that is very important from the surveyor standpoint is that they be able to certify that they have conducted their survey pursuant to these standards. And so we have always focused on factual, objective observations. And we inadvertently in section 5E had a comment in there about the surveyor needing to locate evidence of easements if they appear to affect the property. That's a subjective thing. That's not good for the surveyor. And so we changed that to the objective, whether that feature is on or across the property, which is a fairly easily thing determined versus appears to affect, which is subjective. The utility poles within 10 feet, actually in 2016 is when we pulled observed evidence of utilities off of Table A. They were actually optional in Table A up until 2016. In 2016, we made observed evidence of utilities on the property or within 5 feet of the property mandatory. Those are now required under section 5E Romanesque 4 actually as utility features. The reason we did that is because there were occasions where surveyors felt like, well, that's a utility. The client did not check off Table A item 11, so I don't have any responsibility with respect to utilities. However, that utility feature ended up also being evidence of a prescriptive easement. And then the surveyor ended up with problem because they had focused on it as a utility feature, which they did not need to show, not as a potential easement, which they did need to show. So in 2016, to get surveyors out of that conundrum, we just said, you know what, every utility feature on the property or within 5 feet of the property needs to be shown. What we inadvertently did not do was drag out of Table A some stuff in there about utility poles within 10 feet. That was kind of left hanging out there, and it really should have been brought in 2016. So all we've done in 2021 is bring that that information about utility poles on or within 10 feet of the property. That is now included there as a mandatory item in section 5E Romanesque 4. And Todd mentioned the other thing that we decided was that utility locate markings, and we see these, they're just ubiquitous. We see them all over the place. Those should be treated as evidence, pardon me, as evidence of a utility, just the same as a manhole or a telephone pedestal or a water valve. We need to be treating utility locate markings as evidence of utilities, which also means evidence of potential easements.
Correct, Gary. And that's an item we talked about in the committee for a while, that if you land on a site as a surveyor and it's painted and marked up, it's our responsibility to identify those. If you see a fiber optic line painted across the property, but then you review the title commitment information and there's no easement across that line, well, that's there's evidence of an easement, as you're saying, and needs to be called out and brought to everyone in the transaction's attention. So section 6, the platter map. Let's head into that section. Evidence and locations gathered pursuant to section 5, that's the fieldwork section we just talked about. The boundary, the description and dimensions enclosure, that's also part of the platter map. Easements, servitudes, rights of way, access, and documents That again, part of that presentation of the platter map and the presentation itself. So that's the section. Really not a lot of changes in that particular section, just again, just describing that section for us all today. Section 6, the new title, field locations, is one edit that we did make in the committee. And one reference here we added, it was reference to the recorded document number or parent tract on an original survey. So we added some language there, and Gary, feel free to add a little color to that.
Yeah, what that used to say was that the there's a requirement that the record description of the property be shown on the survey. And previously, this actually said if we were doing an original survey, so we're doing a survey of a cutout, a 2-acre cutout out of 10 acres, the requirement actually in the past said that we also had to have the record description of the parent tract on there. I haven't gone back to see where that came from, but that's obviously overkill. And so the change is simply that the survey needs to reflect the recording information for the parent tract, but not the actual description of the parent tract. That's just a little cleanup item there. This is technical stuff. It just clarifies something for surveyors who might have drawn a conclusion on a previous revision. The fact is that survey measurements are always horizontal. We don't measure on the slope, because if you measure on the slope and then somebody cuts that hill down, all of a sudden you have less property. So survey measurements are always made on the horizontal, but we wanted to make sure that was clear here. I might comment on this one, Todd. So section 6C, there are some significant changes here that we want to make sure are explained. Number one, this is a survey, and I know that some attorneys would like the surveyor to reflect every single Schedule B2 item, which at least in some of our minds, that's not, this is a survey. It deals with matters of survey, easements, covenants, things that are plottable. And so this item has been clarified that the surveyor is going to show the easements and the covenants and the other survey related matters on the survey. What do they burden or benefit? And then there's a list of things that need to go along with that. So we'll make a summary, and we look at the title commitment, and there's, let's just say there's 4 plottable matters. Maybe there's 4 easements, and they are items 5, 6, 11, and 14 in the title commitment. So we'll have a little summary that says, here's the items that are addressed on this survey, and it's item 5, which is a 20-foot gas line easement recorded in this place, and it's on the property, and we've shown it. Right? There was a place in here where, well, let me go on. And then there are about 7 or 8 examples of the types of notes that we might need to put on related to any given easement. For example, it's a blanket easement, so don't look for it on the property. It actually covers the whole property. Maybe the easement, we know that it's on the property, but it's not locatable based on the information in the record document. There are a number of examples of that, and one of the items says that the easement does not cross the property. But we know that there are a lot of people who are interested in whether it affects the property. I have always resisted that because that ends up implying 2 things. It can affect the property if it plots on the property, obviously, but it doesn't affect the property if it's not on the property, right? But what about the legal effect of the document? I knew of a case where I was actually an expert witness in a case where there was an access easement that went up and touched the edge of a piece of property, and yet that piece of property did not have legal right to use that easement. And so I have always been concerned about using the word effects, because an easement might plot on the property, and yet it might not be a valid easement, or it might, there might be some other condition there. So what we've done is we kind of drew a compromise and said, as a surveyor, we will go ahead if you want and talk about whether it affects or does not affect the property, but we're framing the use of the word effects as being based purely on where the easement plots, right? And so that the use of effects has nothing to do with the title or the legal effect of the document, only where it plots. And I think that strikes, I think, a pretty good compromise for those who want to see the use of the word effects, and yet protects surveyors from giving opinions that end up being legal opinions.
Yeah, Gary, that's a great explanation. And I know in the 2016 standards, our intent was to add some language in this section, like you said, for issues when a surveyor runs across an easement that has some difficulty to it as far as reading that description, or maybe it touches the property, or we added quite a few statements in there that allowed the surveyor some flexibility to add more language to their surveys. I think in doing that, we've gone back and looked now in this version and said, well, how do we make sure that the title offices and the title professionals that are using the survey get the information that they need also, without putting undue liability on the surveyors, right? But also getting the surveyor to help make an affirmative statement about that record document. And I like what we've done here. I know we spent many hours on the committee going back and forth with how to recraft some of this language. And you're right, the affects and does not affect is now actually in this section, where in 2016, I think we left some of that out. But I think that from a title perspective, I hope everyone that's listening today takes away from the presentation that we tried to listen to what the use of the survey is, and require the surveyors to go through those documents and provide some affirmative statement, as long as they're comfortable doing that, right? And like Gary, like you said, we have an easement that runs right through the middle of the property, and it's a 20-foot sewer easement, and there's manholes we picked up. Well, I don't believe I have an issue saying, that affects the property. If there's some other document that is written rather strange, and maybe then my focus is the description itself, not the legality of the document.
Right.
And anyway, so I know the committee spent a tremendous amount of time. You and I have talked about it for months also. So I know that's a big change in the 2021.
Yeah, and your point is well taken, Todd, that this committee is not a contentious affair. I think everybody involved in the committee understands that, and I have worked, I'm a surveyor, Todd's a surveyor, but I've been a member of ALTA for a number of years, actually 25 years, and I always felt it was extremely important that I understand what the title people need, what the lenders need, what the buyers' attorneys are interested in, and make sure that the standards address that. And yet we have to address that in a way that doesn't put undue liability on the surveyors, and that the requirement is clearly stated. So, in a sense, it's a fine line there. And yet, interestingly enough, we've never I've been involved with the standard since 1988. I've never been on a meeting where it's been contentious about, well, no, you have to do this. No, we can't do that. You have to do this. It's never been that way. It's always been, how can we craft this language so that it addresses the title industries and the lending industry's needs without putting undue liability on surveyors? Because if we end up in a situation where we're giving an express guarantee or warranty, my professional liability insurance is not going to cover that. So it's a fine line sometimes, but I think we generally strike a really good balance. I might mention on this one, this is another one that looks like there's some hidden agenda on this. This actually ties back to one of the requirements in section 5 that there was a slight modification on. The issue here was that the requirement kind of limited the issue of access to whether the street was a public street or not. And I don't think anybody is interested on limiting that. I think the surveyor needs to be locating and showing access regardless of whether it's a public street, whether it's a private street, whether it's by virtue of an easement, whatever the situation is. And this just cleaned that up. I know I had a lengthy exchange with an attorney who felt like we were really, messing things up with what had been done between this item and section 5. And that is not the case. It actually is probably more beneficial to the title industry, to the users of the surveys than otherwise. It just cleans things up and makes it more comprehensive.
Yeah, good point. Here again, we've just kind of like Gary, you just said, we've just added language to help clean things up. It says include tax parcel number for non-platted adjoiners where available. That change is something that is simpler for a surveyor to obtain, doesn't slow down the process of the survey. And again, just putting in there more language and where the surveyor should be obtaining that information, and then just announcing to everyone how they're going to do it. So that's what we've added to that section.
Yeah, and I think the suggestion to add tax parcel numbers actually came from ALTA, as I recall. Okay. This is a brand new item, and I might take a minute or two to explain this. The problem that surveyors have run into, and it happens in 2 cases. The first case is when in the process of just doing our due diligence, doing our research, maybe I've surveyed the property before, maybe I surveyed the property next door, or maybe I'm just out doing my research in the courthouse. I stumble across an easement that in fact is not listed in Schedule B2 of the commitment, right? That's one scenario. The other scenario is that I get the commitment, it shows an easement, we do the survey, we put the easement on the survey, but it turns out that it's a really old easement and there's actually no water line associated with that easement. There never has been. They might even have trouble figuring out who has rights to that easement anymore. And the lender persuades the title company to insure over it, which of course means it has now suddenly disappeared off the commitment. And now everybody wants the surveyor to remove it off of the survey. The problem with this is from the surveyor's liability standpoint, I'm not concerned about it in the instant transaction, because everybody knows what's happened. But these surveys live on and they go, out into the future. They're out there and people get them, and they are used and relied upon. And the conundrum we have as surveyors is now there is an easement that apparently is a valid easement, but that is not being shown simply because it's not on the title commitment. And I think this puts surveyors in a professional, professionally in a perhaps even in an ethical situation of being aware of a valid easement, but not showing it on the survey. And we had a lengthy discussion about this, and the determination was unless somebody can provide documentation to the surveyor showing that this easement has actually been extinguished, and whether that's a release, a vacation, some sort of abandonment, unless someone can provide the surveyor that documentation, then that easement is going to appear on the survey, or at least there will be a note with respect to that easement, and a note that the title company was made aware of this. And I tell surveyors, and probably a note that says, oh, by the way, this is not listed in Schedule B2. I know there will be a lot of people who probably do not like this because they don't want easements on the survey that are not reflected in the title commitment. but I think they need to understand the surveyor's liability situation of being aware of what is apparently a valid easement and then consciously not showing it on the survey, which is a problem, a liability problem for surveyors. And so that's why this was changed here.
Yeah, you're right, Gary. And this is a section that when I read it, and we in the committee we talked about it, and the first part of this, the first sentence, I just kind of think, wow, why didn't we? It's something we probably could have added years ago, right?
Yeah.
Because it's hey, and I'll touch on that part because you took the second half there of what happens when we have an easement that gets removed out of a commitment. But if I'm performing a survey and I know there's a gas line easement across the property, and I surveyed it before, and the title office missed it in their Schedule B2 listing, this section really says, hey, we're all in this together. Raise your hand and let everybody know. And it actually is written in a way that says, let everybody know before you send your survey in. I mean, let's talk way before we get down the road 2-3 weeks or whatever it might be in the process, and when you're producing the survey. The minute you know about it, let's tell everybody about it. I mean, that's we're all helping each other, and you know, long time ago, surveyors and title companies had a really great relationship. I think we still do today, but let's pick up the phone or let's send an email, right? Let's do something along that line. And that first section just says, as a surveyor, if you identify something and it's recorded and you know it, let's provide the document. Let's tell everybody. Let's get out there and get ahead of that. And then the title office can get that commitment amended. That kind of the opposite of where the next part of this goes, can get it amended, added as item 25 or 18, whatever the last item is, and go down the road, and then we can add it to the survey as that item number. That was the first part of this paragraph, and then the second part, Gary, you expanded on that, did a great job with talking about that. There seems to be a tremendous amount of pressure at the end of the deal for surveyors to make all types of corrections and changes to their drawings, and in some cases it's, well, the title office says this is intentionally deleted, so just remove the text and the easement off your survey. So anyway, you touched on that, but I love the first part of this. I love the communication part. I love that you know, team effort, and that's what we were trying to impress upon the surveyors who also have to use these standards. Let's all work together on these things. So anyway.
Yeah, it's absolutely true, Todd. It's funny that we've never addressed this before, because I tell surveyors, absolutely pick up the phone and say, hey, I found this easement. And I tell them, you know, one of three things is going to happen. Either they're going to say, oh God, thanks, we missed that, in which case, you know, we're all working together and everything is great. Or they're going to say, yeah, we're aware of it, but that was released, in which case I would say, can you send me a copy of that? And then I won't make this mistake again. And then the third thing that might happen is that they're simply writing over it, which we address in the second part. So yeah, I really like this section because it represents a collaborative effort to make sure we're all on the same page.
Oh, table A section. All right, let's dive into this. Yeah, there are 19 items now. We removed wetlands and renumbered. We in 2016 set the standard for if you want to add additional items, it needed to be an A, a B, a C, etc. Gary was instrumental in defining that, so that's still defined, but now those numbers start at 20. If a client and a surveyor negotiate a particular scope item, something outside of even the ALTA standards they want picked up, that's the area in which that's appropriate to define and discuss and then tie into the contract of the ALTA survey. The wording of Table A items is negotiable. As Gary and I were talking the other day, it was intended to be negotiable, and new language has been added to that to kind of tighten that up and maybe explain that area a little more in that preamble, where we say all these items can be made negotiable and can also be edited if necessary.
Right, yeah, well, it's kind of funny because that was always the intention of that preamble, and it was not clearly stated. So this time we made it patently clear that that the actual wording of a Table A item is in fact negotiable. I mean, they're optional anyway, so why wouldn't they be negotiable? So that's been made clear.
let's get into some of the changes. So we'll come right down to table A item 6, which was zoning. And originally in 2016, we had added this language here, you'll see, where we expanded that a zoning report and a letter must be provided to the surveyor. We tied that to the client because everything was negotiated. If you look at the preamble again, the requirements and the surveyor negotiated between the surveyor and the client. But here in the industry, we've learned that sometimes the client isn't the only one with that information, right? And we said it needs to be specific to the surveyed property, but also it can be provided by the client's representative. So the law firm that's handling the transaction, let's say the title company has that information and is sending it. Maybe the title office requested the letter, that can be provided. So we wanted to add language that's not just the client that needs to send that information to the surveyor. And then also we added some clarity to this section that just says being specific to the property being surveyed. That should go hand in hand, but sometimes we need to add some language in the standards that clarify those things.
Yeah, that was an important change because in some cases, surveyors are, basically given the zoning ordinance and told to figure it out. And I'm no more of a zoning expert than anybody else, and I can't interpret a zoning ordinance and figure out how it applies to the property. And generally, the jurisdiction isn't going to help me with that either. And so we said, you know what, if you want under 6A to us to list, basically the 3.1 zoning endorsement, the classification, height, floor space, area, setbacks, parking, then we need a report. We need the information that is specific to that property to be given to us so that we can list that on the survey.
That's right. In table A10, it had a 10A and a 10B. We removed the option for 10B, which was the plumbness of the wall, not something that we see in 99% of surveys. Maybe in an urban downtown area, maybe in DC, something we want to measure something like that. That can always be incorporated as a 20A or an item in that regard. So that's been removed under party walls.
Yeah, and that was one that was very frequently asked for, and yet, you're doing a survey of a one-story brick building, and they want us to check the plumbness of that wall that's 9 feet tall, and it just didn't make any sense. And people wouldn't tell us what wall they were concerned about because they usually didn't know what wall they just checked the item off. And so the determination was, if someone is concerned about a leaning wall, then they can negotiate that under table A item 20.
That's right. Now I think we get into table A11 next. We do. And we spent quite a bit of time here in the committee also. We talk about paint markings that we might find when we land on a site in the fieldwork section. But the reality of those markings when they're ordered or called by a surveyor is they aren't performed. Those one-call services historically and over the past few years and have gotten to the point where they won't do things for surveying companies, and they don't do them in a timely fashion. So we really looked at this section and created two options here for underground utilities. And we're talking about utilities in reference to only underground. All the other items are packed into section 5E, which are the body of the standards, right, which Gary was going over earlier. But the two options now are table A item 11A, which are plans and or reports provided by the client. I've had that happen a few times where the customer says, we just finished these athletic locations. Here's the most recent copy of the civil plans that happened. And that can be relied on by the surveyor. That's one method of doing it. On a standard ALTA transaction with seasoned properties, maybe you don't have that information. So we offered another solution, which was 11B, which is markings coordinated by the surveyor pursuant to a private utility location company or request. This means that the surveyor will have to negotiate a fee with an outside private location service and timing. This means that the field work and the location of those underground utilities will need to coordinate efforts and services to stay on some type of schedule for the transaction, right? So there are a few.
Oops. It looks like Todd may have frozen up there for a minute. Let me expand on that. And I did hear from someone who said, as this private utility locate request, does that mean a request for private utilities to be located? And the answer is no. We're talking about hiring a private company to locate utilities, and there will be a fee associated with that. And so, you know, that's an important item. The problem, as Todd said, was that the 811 locate requests in most parts of the United States, they are not very helpful for surveyors. Right? They don't want to respond. They won't respond, it's just not helpful. It's not a fruitful exercise. Now, if remembering that you can negotiate these items, if the surveyor happens to be an area where, in fact, an 811 locate request is actually responded to in a timely manner, then they could just go over here and they could negotiate to strike the word private out of 11B and replace it with 811. But the people ordering the survey, those of you who are going to be involved in ordering or using the survey, need to, you know, communicate with the surveyor, because surveyors know in their area if 811 requests are helpful or not. And if they are, great, then strike private and replace it with 811. But if it's not fruitful, then leave that as private. Now, this can be fairly expensive. And in addition to the fact that, you know, if it's a large property and there's a lot of private, you know, service lines on the property, 811 is not going to locate those anyway. And the private people might or might not have much luck doing that. But you know, the whole problem we have with Table A Item 11 is that I think people who check it off think that they are going to get accurate, complete, and reliable information on underground utilities. And the note that follows Table A Item 11 is a very, very important note, because what we're trying to do is just provide the user with some factual information to kind of tamp down on your expectations, because unless somebody excavates the site, you are not going to get accurate, complete, and reliable information, because I don't have that information. You know, I don't have X-ray vision any better than anybody else does. All I can do is rely on the markings, which are, by the way, most people may not know, but utility locate markings are at best plus or minus 2 feet, at best. And I've seen, you know, water lines marked as gas lines and all kinds of crazy stuff. So we simply, with that note, it's an extremely important note that everybody kind of understand. You know, we can only do so much when it comes to underground utilities lacking excavation.
That's right, Gary. I'm sorry, I'm back. I don't. The building lost power there for. It's still off, but I'm on battery and my cell phone hotspot, so we'll make it work, right? Yeah, and that section is changed quite a bit. And I don't know if you touched on while I was out for just a second that HUD has included that now as a requirement as part of their 11B as a part of their requirements, which again, if you take a 20 building apartment complex, those 3-story 20 building apartment complexes on 30 acres, a private location service to identify 11B for that is time and cost, like you were mentioning there. And HUD now has required that as part of their scope. So that's something that we also wanted to touch on today and make sure people are aware of.
Yeah, no, that's a really good point, Todd. And in HUD's interim instructions for the 2021 standards, they have said include 10B. We at NSPS are trying to get an audience with the appropriate people in Washington, D.C. I told them I will hop on a plane and fly out there if we can get them. I don't have a problem at all with them saying you need to include 11B. We just want to make sure they understand that this is unquestionably going to increase the cost and the time frame. So we're hoping to be able to meet with them before they issue their final instructions, just to make sure they understand really what is involved in that item. And I see our time is getting up here pretty quick, but I think we're just about done. So
I think we are. Table A item 18, we talked about in the committee since 2016 going forward. And in 2016, we tried to change this to the section you see here, or we did change it to where if a client identifies the wetlands through a wetland consultant and the flags are marked, then the surveyor could identify those items and mark that, similar to we would a utility paint line or utility markings. But as a committee and as we went through this item, we looked at seasoned commercial properties and all the due diligence companies that are involved. We felt as if this item is not necessarily in a surveyor's wheelhouse as far as how all that goes. So we've taken this section out, and what we hope is that the wetlands professional that's involved in the transaction, in the commercial transaction, is preparing a phase 1 or some other document that would help identify this item. So we've removed it from the standards, and Gary, I may have provided way too much information there, but
no, I think that's fine. But
right?
If it turns out that your consultant, the surveyor engineering consultant, actually has wetland services available, and the client is interested, then they could negotiate that under Table A item 20, and right. it just can still go on. In fact, I've already heard that there are some people that are doing that. This last item is, well, it's not the last item, but the one that changed. We reworded this one a little bit. I often tell people it'd be a whole lot easier if I could just say what we have in the last bullet there, which is check this item off, and we're going to survey your offsite easements just like they're a fee parcel, right? But that's too simple. Unfortunately, we know how things are written, and that doesn't get the job done. So what it says is, if you check this item off, we're going to survey that offsite easement pursuant to Section 5. We're going to draw it up pursuant to Section 6. We're going to include all the Table A items that you checked off, other than monumentation, because we're not going to be setting monuments on other people's property. But the point here is that if you are concerned, there's a quarter-mile access easement to get to this property, and you are interested in knowing exactly what's in that easement, then you would check this off. Now, that's going to increase the cost of the survey unquestionably, but that easement will then be surveyed as if it was another parcel. The cautionary note here is understanding if you're surveying a restaurant out in front of a mall, that there may be an REA, there may be cross access and parking easements over the entire mall, and all of a sudden the fee just went from $8,000 to $80,000, and I doubt that whoever checked that item off in that case really was thinking about that. And so I tell surveyors, you need to have that conversation to point out what that means when you've got, for example, an REA.
Yeah, I think also one other good point with the title professionals we have on today is if a surveyor identifies an easement in Schedule B that's an appurtenant easement, and then you move it from there and insure it into Schedule A, that at that point in the transaction may require the surveyor to go back out and survey that. If a lender comes in and says, oh, I want 18. Well, with my client, I didn't know that up front, and I didn't have that information. And maybe we didn't even pick 18 because we didn't think there were any. But then as we went through the process of the transaction, I, as the surveyor, Gary, identified 2 easements that are off-site, and then they became insured. Well, then the lender shows up at the end and says, well, I want the survey data inside that. So that could be a situation that shows up, and at that point, there would be additional cost and timing for the surveyor to return to the property and get that information. It's possible to do it. We do it all the time. It's not difficult to do, but just laying out for you what this Table A item can do if it shows up at the back half of a transaction instead of negotiated up front. So,
right. And if this item is not checked off, you're simply gonna, we're just gonna graphically draw the easement on the survey. It's not gonna be quote unquote surveyed. We're just gonna graphically depict it and say, here's where that access easement is. This item here would cause us to actually survey it and include all the features and that sort of thing. And I think that's I think that's it. Jeremy?
Yeah, it is. Thanks, gentlemen. Todd, thanks for joining back with despite
yeah,
losing power. We're jumping on your
we're
hot
still
seat.
out. The whole building, the whole building's out. I think the generator's spinning up, but I don't know what's happened. We're right in the middle of the country in Norman, Oklahoma. I'm happy to say there's no weather event today. So just FYI, we're safe. The power's just off. I don't know what's happening.
All right, good to hear. No tornadoes. Well, Gary picked up, didn't miss a beat. We will take a few minutes for questions, people sticking around. Or otherwise, if you think of something later, both Gary and Todd's emails are on the screen. Please feel free to reach out to them. Have had a couple of questions come in so far, guys. We were talking about adjoiners. Gene asked, the title company doesn't normally have information about this, so how did it become the responsibility of the title company? Maybe any clarity on that?
Yeah, so interestingly enough, that became part of the standards in 2011, and ALTA, the ALTA members of the committee, which is comprised of about a dozen attorneys, felt like if surveyors need record documents, they should be provided. Now, what I tell surveyors is that the title agency might provide the adjoiners if they're in a rural area. They may be willing to do that, but in an urban or suburban area, they're simply not going to do that. Now, this issue is addressed in a paragraph at the bottom of section 4, which states that if the documents which are listed, which the surveyor is supposed to be provided with, are not provided, then the surveyor needs to do that. And Todd mentioned this earlier, the surveyor needs to do that research which is required pursuant to the standards of their state. And most states that have standards, if not all of them, would require that the surveyor get those adjoining deeds. So I tell surveyors they're probably not going to get the adjoiners, even though ALTA felt like, so that's how it got in there, actually, is that ALTA said, it's a record document, they should be provided. The reality is we know that's probably not going to happen. I want to add one comment onto that, and that is that there are some states where there are no mandatory standards in those states, and those would include California, Minnesota, Pennsylvania, and Florida. I'm not sure of others. It's possible there's a few others, although I think that might be it. So in those states, if the surveyor is not provided the appropriate documents, they don't have any law to fall back on that's going to guide them, and they're going to end up doing presumably and hopefully whatever the normal standard of care is in their state, which probably would include looking at adjoiners. But that's how that got in there.
Okay, awesome. Thanks for that explanation. And question from Lance, and this actually gets back to a little discussion we were having before the start of the presentation about the use of drones. And Lance was asking, is it accurate to say that pursuant to Standard 5, drone technology can never be the sole method used for surveying boundaries? Since it's not
I might address that. We were just talking about that. A drone could be used to locate a lot of different features. Drones are never, this is not a function of Section 5 saying it has to be done on the ground. Boundaries are never going to be able to be done remotely. The monuments, the markers that we find are often underground. The commencing point, if you're in a public land survey state, the commencing point may be a section corner a half a mile away in the middle of an intersection beneath 2 feet of pavement. So there's just no way that any kind of remote technology is going to help us, or is going to substitute the on-the-ground work related to surveying the boundary. It will help us. There are a lot of, not just drones, but there are other technologies that will help us gather data quickly and effectively that can be shown, the sidewalks and the parking lots and to some extent the buildings, although you're going to see, the roof and not the building face. But there's an awful lot of features that can be shown using a drone and other technologies, but they are not going to be effective or able to be used in surveying the boundary. Todd, feel free to jump in.
Yeah, no, you're right, Gary, and that's what we talked about the other day and today also, is that drone or UAV has an appropriate use. But if I'm responsible, my first charge as a surveyor is what I say is to provide a boundary opinion. And I don't use that term legally to represent myself as the wrong type of profession, but my professional charge on any survey I do is I want to make sure my boundary is accurate and that there aren't any issues with that, number one, right? And I'm going to use surveying methods and equipment that are going to allow me to accurately do that and relate and make sure that I'm doing that in a precise way that matches the standards and my state standards in that way. And also, maybe I'm following another surveyor that went behind me. So I don't want to use equipment that might not be as accurate as something that in regards to the boundary. So no, you covered that really well.
Yeah,
they do have a use and a purpose and for certain property types, but not for boundaries, in my opinion, either. So.
Right, and so the answer, Lance, is that these other technologies will never be the sole method to survey a boundary, not because it's not performed on the ground, not because the standards say you can't, but because from a practical standpoint, it can't be done.
Thanks, guys. Much like title space, technology is a nice supplement. Still can't at the current stage replace the expertise on the ground of people. I think we're going to wrap up now. We're about 6 minutes past. Again, if you have any questions, please reach out to the speakers or myself. We'll get your question answered. Before wrapping up, I do need to thank Dell Technologies once again for sponsoring today's webinar. If you missed any part of today's presentation, or if you think others would benefit, again, the recording will be emailed to you, and you can always find all of our recorded webinars at alta.org/webinars. I also just want to make you aware of some other upcoming ALTA Commercial Network presentations. In July, we will discuss proposed legislation that would end the real estate tax break when investors exchange property for gains above $500,000. In August, we'll dig into the impact the changes to the ALTA policy forms will have on commercial transactions. And then in September, we'll focus on the changes to the 47 series endorsements and addendums, this stemming from the Supreme Court decision in the case McGirt versus Oklahoma. So keep a watch out for registration information for those upcoming commercial network webinars. And that will lead us into October for ALTA 1. There will feature an education track dedicated to the commercial segment. ALTA 1 registration is open. And with that, Gary and Todd, thanks again for sharing your knowledge, expertise regarding the surveys and how title professionals can work with surveyors, for our customers.
Yeah, absolutely, it's been our pleasure. Our pleasure, and feel free to contact either of us. You have our information. Yeah.
All right, that brings us to the conclusion of today's presentation. Take care, everyone.